Judgment in the matter of R on the application of Stott versus Secretary of State for Justice.
Lady Black will explain the decision of the court.
This appeal concerns a prisoner, Mr. Stott, who is serving a particular type of prison sentence known as an extended determinate sentence. An extended determinate sentence can be imposed for certain offences when the court considers that there is a significant risk that serious harm will be caused to members of the public by the offender committing further offences. In Mr. Stott's case, it was imposed in 2013 for 10 counts of rape. An extended determinate sentence comprises two elements: the appropriate custodial term, which the judge sentencing Mr. Stott fixed at 21 years, and an extension period during which the offender is subject to a licence, here 4 years. As is the case with other prison sentences, there are provisions for the early release of a prisoner serving an extended determinate sentence. Mr. Stott complains that those early release provisions are discriminatory and violate Article 14 of the European Convention on Human Rights, taken together with Article 5 of the Convention, which secures the right to liberty and security of person. He bases this upon the fact that he has to wait longer before he becomes eligible to apply to the parole board for early release from prison than would have been required if he'd been serving a different type of sentence. The sentencing provisions are complex, but a simplified example will illustrate the point Mr. Stott makes. He becomes eligible for parole once he has served 2/3 of his appropriate custodial sentence. He compares this to a prisoner serving a discretionary life sentence who can apply for parole after he has served a specified minimum term. The specified minimum term is usually set at half of the determinate sentence that would have been imposed if the prisoner had not been sentenced to a life sentence. On this basis, a discretionary life sentence prisoner with a 21-year specified minimum term would be eligible to apply for parole after 10.5 years in prison, whereas Mr. Stott has to wait for 14 years before becoming eligible. This court has had to decide two issues in relation to Mr. Stott's Article 14 claim. For him to succeed, it has to be established that the different treatment of him was on the ground of other status within Article 14. The Divisional Court was bound by the 2007 decision of the House of Lords in the Crown Clift against the Secretary of State for the Home Department to decide this issue against Mr. Stott, and his claim failed. However, this court now departs from the House of Lords decision, having considered all of the case law, and particularly in the light of the decision of the European Court of Human Rights in Clift against the United Kingdom. We conclude, by a majority, that the different treatment of Mr. Stott was on the ground of other status. Lord Carnwath disagrees and would have dismissed the appeal for this reason. The second issue has two parts. It involves determining whether an extended determinate sentence prisoner is in an analogous situation to either a prisoner serving a discretionary life sentence or a prisoner serving a different type of determinate sentence, and if so, whether there is an objective justification for the difference in treatment between the different categories of prisoner. This court decides by a majority that an extended determinate sentence prisoner is not in an analogous situation to the other prisoners. The majority, Lord Carnwath, Lord Hodge and I, considers that prisoners on different sentencing regimes cannot be said to be in analogous situations because each regime is designed for particular circumstances and particular types of offender, and each has its own particular set of rules dictating when the sentence can be imposed, whether and when the prisoner will be entitled to be released, and what time he will spend on licence. Lady Hale and Lord Mance consider that, on the contrary, a prisoner serving an extended determinate sentence is in an analogous situation to the other categories of prisoner. Lady Hale observes that liberty is the essence of the right in question, and for that purpose the prisoner's situations are all relevantly similar. As to the question of justification for the difference in treatment, the court divides in the same way. Lady Hale and Lord Mance consider that there is no justification for requiring an extended determinate sentence prisoner to serve 2/3 of his appropriate custodial term, before he can apply to the parole board for release, when others who have committed serious offences and have been considered dangerous can apply at an earlier point. They would have declared that in relation to early release, the extended determinate sentence is incompatible with Article 14, read with Article 5. However, the majority considers that there is an objective justification for treating the different categories of prisoner differently. The extended determinate sentence regime has a legitimate aim, including the aim of enhancing public protection, and represents a proportionate means of achieving that aim. Furthermore, the sentence must be considered as a whole, rather than singling out the early release provisions within it. Viewed in this way, there no longer appears to be an unfair difference between prisoners. Although the prisoner serving a discretionary life sentence may be eligible sooner for early release, that is offset by the fact that, whilst the extended determinate sentence prisoner has a guaranteed end to his imprisonment, whether or not he gets parole, the indeterminate sentence prisoner has no guaranteed release date and may remain in prison for the rest of his life. Additionally, the discretionary life prisoner remains on licence and liable to recall to prison for the rest of his life, whereas a prisoner in Mr. Stott's position is only on licence for a fixed period of time. In the light of the decision of the majority, the appeal is dismissed.